So we'll start the first session, which is basically going to be about, with all the changes, how are offshore financial centers likely to fare in the near future. So I'd like to, we've got Burke here, if Tim Ridley, Jack Blum, James McConville, and Dan Reeves could come to the stage.
I think it's best sometimes when you're hosting a pro and con panel to stand up and take a step back, so that's what I'll do for the moment. We talked a little bit via email about some topics to address and some beginning questions, so we'll just dig right in. Dear panel members, the fourth EU Anti-Money Laundering Directive was released a few months ago. While there are requirements for increased due diligence for law firms, more clarification on enhanced due diligence, and simplified due diligence for low-risk clients, the big debate is over the vexing issue of beneficial ownership of all entities. It is the new requirement for all companies, legal entities, and trustees to hold adequate, accurate, and up-to-date information on their beneficial owners. They're also required to make this available to those doing due diligence and law enforcement agencies. It's not yet clear whether some countries will interpret this requirement to provide the information as a need to provide it publicly or merely a transactional basis. Who'd like to jump in first on that? All hands go up at once? Jack? Go for it.
Okay. The topic was, what's the future of offshore? To call your attention to the fact we're at the 12th annual conference. And as I said to David this morning, I expect he'll be able to retire on the number of ongoing conferences we have about offshore, because there'll be many, many more years of discussion. The question of beneficial ownership is going to be on the burner, not just for tax reasons. This has become an American national security issue. I don't know if you've noticed the news about Ukraine and the news about Russia and the sanctions against Mr. Putin's friends, but suddenly people have come to realize that Ukraine's mess is a result of grand theft nation, and that money has gone offshore systematically. If you trace back through practically every one of the previous prime ministers and presidents of Ukraine, you'll find a trail of looting of the country. And our method of putting pressure on the Russians is to go after Mr. Putin directly and take a look at his offshore arrangements and structures. The New York Times, in discussing that possibility, referred to seizure of any of Mr. Putin's offshore assets as the nuclear option. I think more and more the question of looting and grand theft nation is going to be on the minds of governments everywhere and will be propelling the push to greater transparency and greater understanding of who's behind various structures. And this business of the use of a structure to get around the various new laws will become a major focus of attention in the next couple of years.
Jump in.
There's this one with, interesting, I agree with Jack in terms of the focus. I think perhaps to put it in perspective, sanctions, etc., are not actually going after offshore assets because the assets are actually not offshore generally. What they mean is going after assets that are obtainable within onshore jurisdictions, not least of all hugely expensive real estate in London and other key jurisdictions. And that kind of highlights the issue. I think we have to distinguish between the assets and the ownership. I certainly agree that I think in the UK it's going to be very interesting to see how this plays out, whether it'll play to Mr. Cameron's advantage in his push for disclosure of beneficial ownership of entities, excluding trusts, by the way, according to Mr. Cameron, and whether that information is going to be publicly available to Tax Justice Network and the other organizations near and dear to Jack's heart. I think that the perspective from offshore jurisdictions is that the looting of nations' treasuries has been going on for hundreds, if not thousands of years, and what's happening in the Ukraine is only an example of what's been going on for many years. And I don't see it as a new development, I simply see it as an example of the same old that's going on. And I certainly think that most offshore financial jurisdictions, certainly the ones that are represented in the room today, do not support looting of national treasuries, and they do not support the hiding of corruptly gained assets. The question is, how do you deal with that in a way that recognizes that law enforcement and regulators and tax authorities should be able to access that information in a timely way and go after the offenders if they are indeed offenders, and the need to preserve legitimate privacy. And I think that's probably where Jack and I may disagree. I think we agree on the principles, but we disagree maybe how you get to the right end. And I'm very leery about abandoning basic rights of privacy in financial, medical, and other areas in order for what some would see as the greater good. I think that's a very unfortunate line to cross.
I would just like to say, I think you have to distinguish, though, between privacy and secrecy. You know, privacy is something that I think everybody can get behind. I mean, I believe 100% in people's privacy. I want my privacy. I don't want anybody being able to find out about my assets and how much money I have and how much money I make and where I keep it. But we've got to distinguish between, and while I understand the need for public disclosure of certain information, such as corporate structures, we've got to distinguish between what is publicly available and what is available for law enforcement, tax, and regulatory authorities. And historically, you know, the amount of information that was available to law enforcement was severely curtailed through the use of offshore structures and offshore financial arrangements, and even to this day still are in many cases. The offshore world may have come a long way, but there is still a great deal of secrecy out there. And I think that really is the whole issue. It's not so much whether people should have privacy, it's whether private people should have secrecy, which enables them to engage in any kind of activity without ever having to even worry that law enforcement may become aware of it, and if they become aware of it, whether they can actually get the records involved. I mean, in today's world with tax information exchange agreements and such, clearly there's been an improvement, but I think everybody in this room knows that tax information exchange agreements, very often the information has to be provided in order to get the information, can't be obtained without getting the information first.
If the privacy and the tax advantages are removed, what do OFCs have, offshore financial centers have to offer?
Good. Well, I've practiced in the British Virgin.
Get close to the microphone.
Oh, sorry.
Sorry.
Which one would you or both?
I'll take.
You can get two.
Why not?
There's a limited number of microphones.
In the British Virgin Islands, where I've practiced law for probably about 6 or 7 years, I guess disclosure of information has always been a prominent issue, and obviously steps towards disclosure of beneficial information and so forth is a concern to BVI and elsewhere. But I think as the BVI regulators and regulators in other offshore jurisdictions have said that disclosure of beneficial information has been a requirement at one level for quite a long time in terms of disclosure to registered agents, and registered agents then are required to disclose to regulators on an as needed and as required basis. So I think the general game plan in terms of offshore jurisdictions remains pretty much the same and will remain the same. The number of incorporations has continued to tick along and so forth. So taking away that issue, then you have to look at, well, what has been ongoing considerations or ongoing reasons other than tax for incorporating companies in offshore financial centres. And really, in terms of my day-to-day practice, tax is, I guess tax has already been considered at an initial level, but tax is very rarely discussed. It's really about the efficacy of the laws in the jurisdiction, whether it be BVI, Cayman, whatever. A lot of effort has been put into actually developing world-class, top-class legislation, which basically takes elements of Delaware, elements of New Zealand and elsewhere, and make it flexible, user-friendly, cost-effective, and so forth. So I think those fundamentals that keep these jurisdictions attractive, keep the numbers of corporations going, will keep going regardless of what the disclosure requirements are in terms of beneficial information.
Taking a look at some of the proposals that have...
Yeah.
Oh, okay, go ahead. It was quiet too long, Jack.
There are a couple of things to think about here that we really should talk about. We've talked about privacy. I would argue that privacy is shot, period, full stop. I'll never forget being involved in a Swiss case where a private investigator came up with bank information, and the challenge was how to get it from the Swiss legally. And the only issue in terms of getting information was how much you had to pay the investigator. It turns out that all of this stuff that is supposedly secret is very vulnerable. And I don't think many of the people even in this room appreciate how easily some investigators can get their hands on offshore information. So that's one point. But the second point is, yes, BVI may have a rule that says, yeah, you have to know who owns the company, but then who owns the trust that owns the company is another issue for another place. And if you get an answer that says, well, the owner of the company is a trust, and in turn that's owned by an insurance policy, good luck. By the time you trace it down, you're probably at the end of the world. But now let's look at the reality of it. BVI is where most Chinese who are stealing from their own governments and are involved in corruption are incorporating their vehicles for doing that. And if there is a great ungluing in China, you can bet that this whole facade is going to come crumbling down, and there will be a hell of a price to pay. Finally, as far as the corporation structures are concerned, most multinational corporations are going to continue to use offshore entities because of our bizarre system of tax treaties set up through the OECD, which allow for this use of different jurisdictions to make income disappear. And as long as that system continues to be in place, sanctioned by all of the major governments, and by the way, this base erosion profit sharing exercise of OECD is probably going to go on the rocks. Treasury people are assuring U.S. corporate people there won't be any major changes. There'll be a market for offshore shell companies. And beneficial ownership in that case won't much matter. What will matter is this bizarre complexity that effectively shields income from taxation anywhere. We have a system that's supposed to prevent double taxation, and what it creates is a system that gives us double non-taxation. So major corporations are now paying no tax at all, negative tax rates. Some of them unfortunately may pay 8 or 10%, even though the nominal tax rate in the United States is much higher. That system is going to keep offshore in business for quite a while unless the U.S. comes to its senses and unless OECD takes major steps. And at the moment, best efforts on the part of the NGO community to the contrary, it looks like the whole exercise is going to go down in flames.
I just want to add something to that, which is that as someone who was involved in law enforcement, you know, Jack is exactly right. Very often you can get information. The question is, can you get it in a way that you can enter it into a court of law? Can you use the information? And that requires getting it legally. I actually remember very well being here at this very conference about 5 years ago and there were two speakers who I think represented a company. I think they were once connected to Mossad or something like that. And I remember them coming up to me and saying, you know, we can get you information out of any country in the world. All you got to do is be willing to pay for it. And my answer was, I work for the IRS. I can't pay for anything. You know, the notion that the information is out there is true, but you have to be able to get it. You have to be able to get it legally. And when systems are set up, regulatory and compliance systems are set up by financial centers, offshore financial centers, specifically to make that as difficult as possible, then it becomes a very difficult exercise to get. You know, as I said earlier, tax information exchange agreements, treaties, those kinds of things are all helpful. But the fact of the matter is, if you know somebody has their money in an offshore financial center, and you just want to know what bank they have it in, it becomes very difficult to get that and get the banking records in such a way that you can actually use them for a law enforcement purpose.
The Brits seem to be getting out in front of this beneficial ownership exercise with a required disclosure of 25% beneficial ownership or greater being required. Do you think that they're trying to front run this to get the number higher as a tactic, as opposed to letting the OECD come in with a lower number?
I'm not sure. I just wanted to go back to Jack's comments, because I now think that Jack should probably offer himself as a consultant for the promotion of offshore financial centers, because his cynicism about some of the international initiatives which are now underway are encouraging for those of us who are not particularly keen on the OECD lecturing people about the tax they should pay when the people doing the lecturing themselves don't pay any personal tax, but that's an issue that will continue to be raised. But I think, just moving back from the beneficial ownership, I think if you want to see a case in point that is on the front of the Wall Street Journal and on CNBC every morning, which highlights some of the issues that Jack has touched on in terms of where will OFCs be and how will they interface with the major onshore jurisdictions, and that is the debate that's currently going on as to whether Pfizer should be allowed to merge with AstraZeneca. And as you in the audience will know, corporate inversions so that US companies could move out and enjoy a lower global tax rate by redomiciling to Switzerland or Ireland, or dare I say it, the UK now, which is rapidly moving to the forefront as an offshore financial center. One of the arguments put forward for Pfizer buying AstraZeneca is it will then become a UK company and will enjoy a headline tax rate that's considerably lower than it currently pays in the US. And the political debate, which is why it goes into what Jack was talking about, the debate that's now going on in both jurisdictions in the US and the UK is fascinating. In the US, there is a major lobby saying we should not allow the likes of Pfizer to debunk out of the US for tax reasons, but also for scientific reasons. There are people around the US who are now saying, if this happens, we will lose our jobs. Funnily enough, there are people in the UK saying almost exactly the same thing about losing jobs, but they're also saying, absolutely, this company should be allowed to move to the UK, and we would want certain commitments as to what it's going to do, but we actually promote ourselves as having a lower tax rate. We also promote ourselves as having a patent box company regime, which is extremely competitive. Therefore, we would welcome the move, provided all the jobs stay in the UK and our research facilities, etc. But the friction between where these companies pay tax and how much they pay is very much on the agenda. But there is no commonality, and the idea that the OECD is going to be able to come up with a regime that meets the competitive instincts of major jurisdictions is going to take a very long time. It may well happen, but probably Jack and I and most of the people in the room will be long gone. So I think the friction in that case highlights the way in which these deals work and the way that companies very much look at the overall tax bite as part of a legitimate economic planning process. And I know that there are people who think that that tax should not be taken into account in deciding where you domicile your company and how you do business. But the fact of life is that tax is right there on the agenda when multinationals decide how they're going to proceed. Going to the beneficial ownership issue, I think it's a fascinating way in which the UK has developed its approach. I suspect that the Conservatives got blindsided by the Lib Dems, and those of you in the room who are familiar with the way the UK government is currently constituted, it's a coalition with Lib Dems being the minority party, very much the minority party. And I think Mr. Cameron and his Conservatives thought this was an easy giveaway to the Lib Dems and Vince Cable, who is the business minister, and he comes from a Lib Dem background, having worked for Shell Oil Company for most of his life, which says a lot. That they thought that giving this bone to the Lib Dems and saying beneficial ownership of companies should be public, and not only should it be public, it should be freely available on request, was something that was a nice giveaway. And I think Cameron is probably regretting that decision. Indeed, I suspect that his friends, most of whom in the cabinet are of families with fairly wealthy backgrounds, phoned him up and said, do you realize that our families are going to have to disclose a lot of their assets, and that might not be the best thing. So Cameron then wrote a private letter to the EU Commission saying that when he thought the disclosure of beneficial ownership was a good idea, he didn't actually think that extended to trusts, which of course was a sort of get-out-of-jail card for everybody, because of course most significantly wealthy families in the UK, their assets have been held in trusts for years, and quite legitimately, I may say. So the question of how Cameron's going to finesse this, if he has to, significant pressure is being put on the offshore financial jurisdictions. The BVI knows that, Cayman knows that, Jersey, the Isle of Man, Guernsey, and they're very much, the attempt is to set them up on this one. And I hope personally that, and professionally, that the relevant territories will resist the pressure being put on them, and it is very significant, because the UK has done nothing yet legislatively to implement this new scheme. And the word from London is that, in fact, it won't get on the statute book anytime soon because of the parliamentary agenda, which means that it may not happen before the next election. So I think there's a lot of miles yet to run on this one, and I think it would be a huge mistake for any of the Crown dependencies and offshore territories that are under the thumb of the UK to concede on this one. And I think that hopefully they won't, and that if any commitments are made along the lines that beneficial central registry of beneficial ownership will be developed, that if that is developed, it will not be available to the public. It may well be available to law enforcement and regulators and tax investigations because it's available already in one form or another. But that any publicly development of a public list would be a huge mistake, and I think all of us in the room realize that. And any commitment to develop that beneficial registry should be made on the same basis as commitments were made to the OECD on harmful tax practices, that they are contingent on that becoming the globally accepted standard that is actually implemented, and the heavy emphasis being on implementation, because I currently don't hear anything coming out of Delaware or Nevada or Wyoming or Panama or other jurisdictions that they would even start thinking about that. So it's a huge issue. I think the UK has made a big mistake. Hopefully they will find a way of finessing it, but they are under significant pressure, not only domestically, but from the EU. So yes, it's a big issue, and there's a lot of miles yet.
The OECD has made a big point in howling about unfair tax competitions. Nations should not unfairly compete with one another based upon tax. Pascal Saint-Amans, head of the OECD Center for Tax Policy Administration, speaking about the base erosion and profit sharing scheme proposed, is that we are on our way to a fairer tax system where billions do not slip through to tax havens. But what's wrong with competition? The U.S. and the EU make a big point about competition is good for business, and those businesses are more responsive to the customer's needs, do well, and without competition they do not do well. What's wrong with competition amongst the different nations for taxpayers, like Pfizer? Go ahead.
What's wrong with it is simple. The business of government worldwide is not to subsidize corporate activity. It's to provide for the welfare of its citizens. And subsidizing corporate activity does not flow down to the average person. And if you go, as I've been in the last number of months, to different places in Africa, the pressure on those governments to grant concessions, to put up a deal where you're exempt from tax for 10 years if you'll open a mine, are really very painful as far as average people are concerned. In some of these countries, you're talking about half the population living on $2 a day or less, and here is a government that's being told, well, if we're going to open the mine, what you have to do is give us a 10-year tax break or a 20-year tax break or a concession on whatever royalties might come out of the mine. This is the kind of stuff that has led to what Kofi Annan is talking about and what others are talking about. We really do need a debate over this issue of subsidization and why that subsidization should occur. There was just a case of a car company, Toyota, moving from California to Texas in exchange for literally a $40 million payment by the state of Texas to Toyota to move. Now, that makes no sense at all from the point of view of an average citizen. Why should that be the way that companies compete? In the world that I grew up in, the idea of competition was competition based on quality of product and lower price, not on how much money will you pay me to support my semi-monopoly corporation in its various enterprises so it can pay its executives more money. That's not what government should be about.
I think you also have to worry about tax competition becoming almost a nomadic lifestyle for corporations. You know, it's today we're here and tomorrow we're there and the next day we move somewhere else, all to save on taxes. And tax becomes the driving force behind a corporate profit motive. We make money off of our taxes. We don't make money off of selling products and selling services. All of these things don't work well for the greater public good. You know, in the United States, we recently had a Supreme Court case where you know, corporations are now viewed as almost as being citizens, even to the point of having religious rights. You know, well, if that's the case, you know, don't they have citizenship requirements? You know, I mean, I can't tell you how many times as an investigator I walked into a major U.S. corporation to ask questions and was told, we want to be good corporate citizens. That was the first line. We want to be good corporate citizens. Well, you know, good corporate citizen pays their taxes. They support their lifestyle. They support the economy of the country that has provided them with all of this benefit that has allowed them to become a major international corporation. Not allowed them, I mean, they earned it, but I mean, that provided the facility for it to occur. You know, I'm not saying that people don't have a right and that corporations don't have a right to move, but when does tax competition become tax piracy? When does it go from, we're going to seduce this corporation to move into our jurisdiction, and a year from now some other corporation is going, or some other jurisdiction is going to seduce them again, and we get to a point where we start looking for the lowest common denominator, which is where the corporations pay no tax, and their entire profit motive is based on tax, and they're not paying anywhere. They're living a nomadic lifestyle that doesn't pay for a generation of services for the common good anywhere. And is that really what we want? That would be my comment.
Well, one slightly tongue-in-cheek solution, but it is a solution that's put forward by academics, is to get rid of corporation tax entirely and simply to find other means of raising the revenue that you wish to garner to support the government services that you think you need. And corporation tax does not necessarily have to be part of that process. And I agree that the current scenario that we have leads to tax competition, and I think this Pfizer, AstraZeneca, the fact that a company like Transocean has moved from the United States to Cayman to Switzerland, and some of its competitors have now decided that Switzerland isn't quite right for them for various reasons, have apparently decided that dealing with Heathrow Airport is where they want to be, and they're moving to London and or to Ireland, and that's become a very common trend. And those of you who are interested might want to read the various SEC filings as to why these moves are made, and funnily enough, the reasons given for each move are almost exactly the same. and tax isn't actually mentioned. And when Transocean moved from the US to Cayman, there was a list on about 2 pages of reasons why they did it. And when they moved from Cayman to Switzerland, the list was almost exactly the same. And when Weatherford and other companies now deciding that Geneva isn't quite where they want to be because they're fearful that maybe a cap will be put on senior executives' pay, or they won't be able to get the necessary labor that they want because of the Swiss decision to cap immigration again. The same reasons are given as to why they're either moving to Dublin or to London. And of course what is interesting is to see whether in 5 years' time they decide that the place they really need to be because the airport is really good and communications are great is Monte Carlo or Ulaanbaatar. So, but I think that I think that as long as we tax corporations in the way that we do, that tension is going to exist, and the debate should be rather different. Are there better ways of raising the revenue you need for your government rather than reviling corporations? Interesting, last year, when the OECD proposals on BEPS first came up, there was a very interesting conference which is available on the web, sponsored by Oxford University Business School. And some very, very thoughtful academics and business people were all in the room talking about how you developed a fair and reasonable tax code for corporations. And the tax director of BP, who fortunately wasn't involved in polluting the Gulf, he was talking about tax and what BP... He basically was very forthright. He said, you guys, you governments, simply tell us what you want us to pay and how you want to pay it, and we will pay it. Give us certainty. But, he said, if you develop a set of rules that say this, this, and this, you must not complain if we set up our affairs in the way that makes best sense for us, which reduces the tax that we pay. And I do know that traditionally the view of corporate lawyers has been that boards of directors are obliged to run the corporation in the way that is in the best interest of the shareholders. Now, that doesn't always happen, we know, not when it comes to remuneration, but the basic principle which is enshrined in Anglo-Saxon corporate law, and there has been a school of thought that's developed a slightly different way of looking at corporations that takes into account their community responsibilities, and that debate is very worthwhile. But the view expressed in a legal opinion that I think Tax Justice Network got out of a leading private client Settle Land Act law firm in London, that said that directors were not actually obliged to minimize the tax bite of the corporation on whose board they serve, was a very carefully put together opinion that if you read it doesn't quite say what people say it says. And it seems to me that the obligation of a board of directors, tax planning is a legitimate part of that process, and if we were to get to a stage where boards of directors consider that they were not obliged to take the level of tax into account in terms of deciding how corporation should run its business, would be a very sad day. And actually it would be a very sad day for the shareholders. And when Jack says that individuals in the community don't actually benefit from corporate activity, 2 points. One, most major corporations like BP, AstraZeneca, a major bulk of their shares are held by pension funds, and the idea is that pension funds pay pensions to people who are people like us in the room and Jack perhaps. So I do think we need to bear that in mind, and dismissing corporations as simply being aggressive and greedy I think is a mistake, and that they do contribute to the overall benefit of the population in many cases. I don't hold any brief for resource extraction companies that go into African nations and demand concessions and basically rape the country and destroy its environment for the extraction of profit. But the point I would make to Jack is that if a resource company comes to an unnamed African country and says, we want to develop this mine for you, but this is what we want, the African country can, of course, say no.
I'd like to just add a couple of items to that debate. I want to go back to AstraZeneca and Pfizer. What hasn't really been talked about in that inversion is the fact that Pfizer has a pile of money offshore already. And what it really wants out of this is to have that money escape any taxation in the U.S. and that inversion will help it do that. And that's sort of not looking forward, that's looking back at a pile of money they already have. But as far as this argument that, well, the corporation really is the average person, it's not. There was a time when there was broad shareholding, and there was a time in the United States, for example, when people really did have pensions that had money invested. These days, the number of people who have money invested in pension funds has been declining. If you've seen any of the statistics on what's going to face the next generation of retirees, it's going to be perfectly clear that this corporate profitability sure as hell isn't going to help them. And in the end, this is going to be a government and tax problem. And this is a debate that has to be had publicly. And we have to look very carefully at the numbers of people who benefit and who benefits. And I would point you to the recent book by a French economist who's noted that the returns are disparate and going mostly to the people who have assets and capital and not to people who work. And that is a system which is going to bring us to real political and social trouble in short order if it keeps going at the pace that it's been going at.
I just want to add one thing, which is that, government requires a certain amount of money to operate. All governments. I don't care if it's the United States or if it's the Caymans. Every government needs a certain amount of money to operate. And we can argue, and we do always debate, whether they're spending it in the right way on things that really benefit society. But the fact of the matter is it needs a certain amount of money to operate, and it only has certain ways that it can get that money. And the approach in the United States historically has been to spread the burden, the tax burden, across individuals and across corporations and across other kinds of entities. And if you got to a point where you were to say corporations pay no tax, which I know is very popular amongst many people because theoretically that will lead, I assume, to bigger profits, which will lead to more jobs, which will lead to bigger bonuses for the CEO and such. Where's the money going to come from? It's going to come from the rest of us who are sitting in the room, at least those of us who pay tax. It's going to come from people who probably least can afford to pay it. So the notion that we just, we make corporate taxes go away and somehow that's going to be the end all, I don't think that will happen. I think what it'll do is simply shift the burden to others. And that political reality has to be understood, and in a country that it has a representative form of government, or theoretically does, those kinds of issues are going to be very, very important. I don't see any way that you could ever get to a zero tax policy on corporations, certainly not in the United States. And if you did that, then I think, unless you go to some sort of global tax requirement that no corporation pay tax anywhere, I would think we would start getting a lot of reverse inversions.
Just add to the debate, and this is getting maybe a little bit off the topic, but it is fascinating. The suggestion that you abolish corporation tax because a corporation in theory is just combines of the people who own it. I'm not suggesting that you should abandon taxation. I'm simply saying that some of your problems might disappear if you simply look through and you developed a system whereby, as exists in the US, with your transparent flow-through companies, maybe the debate should explore rather more specifically how you deal with that level of taxation. And as I say, my understanding, most small businesses, etc., in the US, operate on the basis where the individual owner is subject to it. So you avoid double taxation. I mean, when we're talking about double non-taxation, there's a very strong argument that if you tax both the corporation and you tax the shareholders, you're actually doubling the same amount of economic activity. So I'm not saying that you should abandon the idea that generation of economic activity and profit should not be taxed. I'm simply raising the question of where you should tax it.
Yeah, of course, this brings us full circle back to the comments you made about how awkward it would be for the conservatives in the Parliament if indeed there was an identification of beneficial ownership. because, by God, maybe some of them would have to pay tax.
I knew that one wasn't going to get by. James, there are other ways to compete than just taxation. For example, would you like to, as an oligarch, would you rather settle your case in Russia or London or New York? Okay. Yeah, the cost of a writ to fix in Russia is a lot less. All right, James, if you take a look at, let's say, Turkmenistan has been converted by the OECD and has said, yes, 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 these are all the right things to do, including beneficial ownership disclosure, tax information exchange agreements, etc. How comfortable would you feel about the government of Turkmenistan and their ministers understanding and possibly misusing information? I mean, that's never happened that anyone would misuse tax information.
It's interesting just where things
Get the microphone.
where things are going in the whole area of tax information exchange agreements and so forth. It's obviously with issues of the OECD and crackdowns on offshore financial centres and so forth a few years ago. TIAs were sort of the flavour of the month in order to provide for the legitimacy of offshore financial centres. And I think as time goes by, there's questions or just how effective these exchange agreements actually are. Like, speaking from the BVI's perspective, it's all about making sure that there's information exchange agreements with as many countries as possible. But for clients in, say, Russia and so forth, basically the question now is how to actually get around these exchange agreements rather than actually complying with them. So other than a headline sort of effectiveness in terms of sort of saying, okay, we're legitimate because we've got a certain number of tiers, I'm not quite sure that just the practical effectiveness of the agreements, but it's something that is starting to sort of play out in terms of litigators in BVI, Cayman and so forth being asked, the client or registered agent, whatever, has been hit with a request from the regulator for information because in the European, Australia or the US or whatever, all sort of channels have been exercised to try and get that information. Well, what do we do? Do we need to comply? What are the considerations about complying and so forth? So I don't know. I think it's just basically something that's all the offshore jurisdictions have to do it. They have to comply. They have to get to a certain number of exchange agreements, but the practical consequence of that is still is still to play out, I think. So.
I think one of the problems that talking to practitioners in all these jurisdictions, and Dan maybe will comment further on this, is the theory of these agreements, and of course exchange of information on request is now moving to a standard of automatic and spontaneous, and quite what you do with a wheelbarrow of information, if you go to that process flooding into people's computers, is another debate, and maybe over time that can be developed into something that's useful. But the problem is at the moment that even if you have a request under a tier, a legitimate request that meets all the standards, and you can go down and tick the boxes as to whether it falls within the framework, the question is, does that information that's required actually exist in a meaningful form, and where is it? Because in this global environment that we're in, and it's quite legitimate too, if you have a hedge fund or an investment fund formed in an offshore jurisdiction, the management company may be in an onshore jurisdiction or maybe in a mid-shore jurisdiction like Singapore or Hong Kong, and the accounting may be outsourced to India, quite legitimately under the way these things happen. And so the theory may break down in the practical implementation in a timely way. And that will inevitably lead to frictions and complaint, and that has existed over the years. And I know from personal experience the timeliness within which information is supplied and the question of whether it's in a meaningful form. And maybe those issues will be resolved over time, but I don't think it should be used as a criticism to say these things don't work. It's simply that in the global environment that we operate in, the idea that all of this information is nicely packaged in one office, in one computer, in a jurisdiction where a button can be pressed, that just isn't the case. And I think Dan's experience probably would support that.
Well, I would agree. First of all, I think, setting aside automatic exchange of information, which is a whole different ball of wax, because there you get into also the compatibility of systems between the systems of those providing and the system of those receiving, and how you manage that in an electronic way. But when you get down to the actual notion of tax information exchange agreements and the kind of information you get and the timeliness of it, certainly in the United States we're dealing with a statute of limitations during which time you can bring an action against a taxpayer. And so when you get these delays, it really only benefits the tax evader who is trying to avoid paying their tax or evade paying their tax. And so when you get these layering issues that involve a BVI corporation and a Cayman bank account and a trust in the Turks and a management agreement somewhere else, and you have to follow the line one step at a time. You have to break through this jurisdiction to get to the next jurisdiction, and then that takes you to the next jurisdiction, and then that takes you to the next jurisdiction. And then when you find out that actually when you asked who the beneficial owner of a particular corporation in the BVI was, through the tax information exchange agreement, they provide the information and even provide it in a timely manner. But they don't tell you that there are 5 other corporations owned by the same individual. And those have all the money in it, those are the ones that are really controlling the wealth of funds, So then you get to the argument, well, let's say we ask just for any corporation that this person has, and then we get the oft-thrown fishing expedition thrown at us, that you're off on a fishing expedition, which actually it's not, it's just good investigative work, So I think that there is a real issue with regard to being able to get information in a timely way and maneuver your way through all of these individual tax information exchange agreements out there. My question is, or comment is, that sometimes they are set up so complex that getting the information through tax information exchange agreements is like setting up the original tax evasion scheme in the first place.
Well, what this discussion brings to the fore is a problem, a huge problem, which is really being debated right now in a number of offshore jurisdictions, which is the responsibility of boards of directors and the responsibility of these offshore corporations to be something more than a shell. There were, for a period of time in Cayman, shell banks, where the only thing you had was a banking license in Cayman. But if you went to Cayman and said, give me the records of the bank, no one in Cayman had them. If you were asked, what does the bank do, or what do its books look like, or what are its assets, all they had was an annual report provided by some accounting firm somewhere. But they couldn't really tell you very much. Now that stopped. Now the question will be, will corporate service providers be responsible for the activities of the corporation that they are on the boards of directors of? And yes, in this multinationalization of things, a shell corporation here and another shell corporation somewhere else, the question is who's responsible? And that issue of responsibility cuts wildly beyond the issue of taxation. And I suspect many of the people in this room, especially those who are tracing assets, who are going after people who've made off with funds that have gone walkabout, will be very interested in having resolved. There should be responsibility. And the idea that you have shells and no responsibility is really a very troubling one. So I think that ties directly back to the question of disclosure. If you disclose the names of people who are on 150 boards and have no idea what the corporation does, or for that matter, who's really running it, what have you got? Not much. I think that has to change.
Sure, sure.
Jack, you'll be encouraged to know that, and I mean, I agree with you, there is technically no such thing as a nominee director, and the idea that there's something as a shell company, you know, a conch shell you put to your ear, but I know what you mean. Out of the 2008 financial crisis, the idea that directors of offshore companies should be called to account definitely came very much to the forefront with unhappy investors in mutual funds, hedge funds in Cayman, the BVI, and other offshore jurisdictions. And there has been significant amount of litigation, sometimes brought by liquidate, and properly so, and progress. And, you know, of course, Mr. Madoff was actually sitting in New York, not in the BVI or Cayman, but, you know, Jack would have got him if he'd been around. Well, he was got him.
He's still sitting in New York.
He's still sitting in New York, yeah, for 150 years. But the significant litigation has developed in the offshore jurisdictions, as I say, principally brought by liquidators trying to trace assets, trying to hold directors to account, and some of those directors have also been sued in the US. Most of those cases do get settled for various reasons, sometimes by insurance companies, sometimes by liquidators giving up because they find the directors don't actually have any assets, which is a point. But as we know, there have been some quite leading cases in the BVI and Cayman, and James can comment on the BVI ones, where directors have been called to account, and for significant amounts of money. So the system does work when it gets before the courts in these jurisdictions. So I don't think that anybody who's a director here of 150 companies sounds a bit low to me, Jack. You know, let's try 500 or 1,000. I don't think that people who are still pursuing that business model should be under any illusions that it's not just if you're on the board of a hedge fund. If you're on the board of a company for oligarchs from unnamed countries and it transpires that you've been shutting your eyes to or ably assisting the movement of those funds, there is a significant risk that you will be called to account.
I don't know why. What was it last year? A Chinese immigrant in New Zealand who worked at McDonald's was arrested as a director of a North Korean arms shipment company. I don't know why that's a problem.
What's wrong with that?
She's very entrepreneurial.
Clearly.
Change is inevitable. Some resist change and some embrace change. 30 years ago, intangible assets were maybe 20% of a company's balance sheet. Now intangible assets represent over 80% of the value of listed companies on S&P 500. The Dutch reacted, interesting enough, to that and set up an entire court system just to deal with intellectual property, an interesting innovation. So OFCs are no different in the face of legislative changes and international treaties. Business now being conducted worldwide at the speed of light. So who is resisting change? How and why are these OFCs failing or being successful? Who is embracing change? And why are these OFCs failing or being successful? Just jump in on any particular jurisdiction or thought. Not all at once.
I don't see any of the leading offshore jurisdictions actually resisting change at all. Actually, I think in terms of any that perhaps initially were seen to be a little bit recalcitrant, I would say probably Panama led the pack, and some others like Anguilla and so forth. But I actually can't think of any now that are steering clear of the sort of the global movement towards appropriate money laundering legislation, appropriate laws dealing with mutual funds, captive insurance, all that sort of stuff. I think all these jurisdictions are seeing the writing on the wall that if they're going to survive, they have to embrace the global trends rather than resist them to get business. Yeah. So that'll be my sort of perspective on it.
My only comment would be whether it's really a progress or whether it's a shuffle.
Progress or
a shuffle.
A shuffle.
Are we simply redefining the way that we do it? You know, I mean, there was a time, at least in tax evasion, when you went to an offshore secrecy jurisdiction, and hopefully this doesn't exist, I'm sure it doesn't exist to the degree it was, but you could just go there and open up a bank account in your own name, and no one would ever know about it because of secrecy. Then things started to change, and well, now we need to start putting them in the name of corporations. You know, when the qualified intermediary program came in 2001, I believe it was, this was one of the major parts of the Swiss issue, is that the Swiss banks all started saying, well, we can't take U.S. clients anymore because we've signed these agreements with the U.S. government. So what we're going to do is we're going to form BVI corporations for each of these people. And now our client is not the individual, it's the corporation. There's always, you know, tax evasion is probably the second oldest industry in the world. And there's always going to be people who are going to be looking for ways to avoid it. And in my own mind, I've seen so many times when progress was made, and instantly there were ne'er-do-wells, if you will, who instantly started looking for, okay, well, how do I get around this law? And I'm sure that's going on today, just as it did after the Qualified Intermediary Program. I'm sure there are people looking for ways to get around FATCA, and ways to get around this and ways to get around that, and that's why we all stay in business constantly.
My candidate for the dumbest response to change, the least sophisticated, is Switzerland, which has had in mind that it can continue doing what it does in the face of all sorts of investigation. And what it's taken on the part of the U.S. government to just pry loose the information that Swiss banks have about U.S. nationals who they helped figure out how to evade U.S. tax is emblematic of what the Swiss have been up to. It's delay, stall, come up with alternatives. Pretty much the day after they agreed to give up information and sign these various deferred prosecution agreements, the Swiss banks were out there saying to their people who had been the client representatives for the banks, guys, you're fired. Now go out and set up a separate consulting firm and come back to us when you have a proper structure that allows us to say we don't have any American customers. Now, that's the kind of attitude that the Swiss have been putting forward. Their idea is if you wait long enough, all of this stuff will blow over and you can go back to business as usual. Well, the news is they can't, and it won't blow over. And I think there's going to be a play out to this, which is going to be increasingly ugly. There are Swiss bankers who are going to jail because they've been caught here in the U.S. and they're being prosecuted. And what they're going to do is give up information about what's been happening inside their banks. So with all of the supposed change in Switzerland, boy, it hadn't been as much as advertised. Now, the one other thing, though, that's gone on, which is terribly important, is a tremendous number of wealthy customers are scared witless of the situation because they really don't know when their customer's representative, who's handling all of their money, is going to decide that he doesn't want to be prosecuted somewhere, and he's going to trade his customer list for 5-10 years worth of time in a prison somewhere. And that, to me, is one of the most important aspects of change in the system. And I think it will continue to be an important aspect of change in the system. People simply don't trust, on an individual level, the banks and the various customers' representatives to protect their assets properly. Now, as far as jurisdictions responding, the smartest responses have come from places like Jersey and Cayman, which are focusing on the not tax evasion, but the various systems that corporations use and high net worth individuals use to set up structures which are arguably within the law, which have the same effect, but which are defensible and which no one can go after either the institution or the people involved because, by God, it's been vetted by the lawyers and the Congress of the United States or the Parliament have left loopholes that make this sort of thing possible. that kind of business is still very much going on and is, for all practical purposes, legitimate. I think there'll be more change over time and there'll be a constant fight over it, but the smart jurisdictions have moved to the legal but avoidance opportunities as opposed to the blatantly illegal.
But those are the jurisdictions that have sophistication and long-standing involvement in financial systems. You know, the smaller jurisdictions that we all know are out there, and you know, the Panamas and Mauritius and all of those kinds of places, they're not going to get involved in that kind of stuff. And what they're going to do is they're going to become repositories for the very kind of abusive, blatant, flagrant tax evasion that used to go on through Swiss banks. I found it really interesting at the recent hearings that Senator Levin and Senator McCain held on Credit Suisse. The new CEO of Credit Suisse, who is an American citizen, basically did what we call a mea culpa. He got up there and said, we accept responsibility for everything we did. We were to blame, and we are not going to do this in the future, and so on and so forth. And then the papers the next few days was all of the Swiss employees of Credit Suisse infuriated that they were being thrown under the bus because they thought this was all normal standard operating procedure, that this is the way it works, you know. I've always point out that Wegland Bank at their, when they pled guilty in New York in federal court, the first thing they said was, well, we only did this because all banks in Switzerland do this.
I agree with many of the comments that have been made, and I think the either greed or stupidity or naivety of some of the Swiss banks, and it would appear that more and more of them were in that category. For a long time, Credit Suisse looked like it was going to escape, but it now looks like it's going to be in an even worse position than UBS, based on some of the reports that came out yesterday in the Swiss press. The interesting point about who will survive and who may fall by the wayside is certainly the barriers to entry for somebody who wants to develop an offshore financial center, whether that's onshore or offshore. The barriers have become much greater. Of course, the most likely candidates are the UK, other places within the EU that have special lobbying powers in Brussels, and of course the US itself, which will continue to demonstrate that tax competition is alive and well. Interestingly, the comments about Panama I find intriguing. Burke wanted to talk, and I hope he doesn't want to talk about Singapore, because some people have different views. Next topic about Singapore. But Panama is booming, and having the biggest engineering project in the world does help to give you leverage. And the strategic value of Panama means that the political pressure on Panama is different from the political pressures on smaller jurisdictions. But Panama, and those of you in the room, are there many people from Panama here? But those of you in the room who visited Panama recently, I think will agree there's a real estate boom going on down there. And many of the institutions, financial institutions that in the good old days had regional Latin American headquarters in Panama but closed them when the United States president decided it was a good idea to invade Panama, and Panama became unacceptable, and they then moved their regional Latin American offices to Miami. Many of those institutions are reopening in Panama, and the Swiss banks have become a major presence again in Panama. So I think Dan's point is an interesting one, but Panama has clearly taken the view that it's going to redevelop itself as an offshore financial center, and seems to be doing so successfully. And some of the comments quoted in the press from the leading law firms in Panama were such that Panama is going to make haste slowly, bringing itself into line with some of the international initiatives we've talked today. But I certainly think that Panama sees itself as becoming, once again, the private banking investment center for Latin America and potentially for other countries in the world. So I think watch this space as far as Panama is concerned. But for smaller countries, we've seen some of the Caribbean nations that are represented in the room and some of them not represented in the room trying to develop an offshore financial center platform and not really succeeding. and it is becoming more expensive, it is becoming more difficult, and to get the professional expertise and the infrastructure in place to do it is getting increasingly expensive and increasingly difficult. It can be done, but of course, typically history suggests that somebody in the top league has got to make a big mistake for that to happen, and history suggests that mistakes are made and can be made. Bahamas made some huge mistakes. Bermuda made some mistakes. Nobody is immune from making mistakes. And those mistakes come about domestically, not internationally. And I think the concern I have about small offshore financial centers, touching on what Dan said, is the governments of these countries have to raise revenue to pay for services their community wants. And they wrestle with the same issues that the United States and the UK and the French. How do you pay for the services people want? How do you pay for the roads? How do you pay for the airport? Et cetera, and how do you provide a distributive wealth effect on the whole population, not just the select few? And those debates may come as a surprise to some people in the room. Those debates go on in places like Cayman, the BVI, Bermuda, just as they do elsewhere. Unemployment is an issue. Developing how do you pay for your health services, how do you pay for pensions, all of those issues are the same where people live. So the cost of doing business in these jurisdictions is going up, the compliance burdens are going up, and I think the most significant threats to OFCs are actually domestically, not internationally. How do you continue to run your governments, run your countries on a no direct taxation basis without pricing yourself out of business?
I think the comment about Panama is a minor minister there told me that the secret to the Panamanian growth is that Latin America is run by a combination of populists, Marxists, and economists. Therefore, their growth should be strong. Speaking of jurisdictions, Singapore. Thank you for the lead-in, Tim. Singapore's economy has been ranked as the most open in the world, least corrupt, most pro-business, with a low tax rate of 14.2% of gross domestic product. So what is the miracle of Singapore? Why is this OFC not just surviving but thriving? And also, what would be a quote-unquote killer app for Singapore? What could they do next to set themselves apart?
Why don't you tell us? You clearly think that, so you should tell us.
Oh, I have one very bad idea. As I see it, the only hold that the OECD and the U.S. have on non-compliant countries and territories is the power of the Fed money wire system and the SWIFT system. What if Singapore were to develop an alternative payment system through them? Then the SWIFT and the FedWire don't have any hold over them. Just a thought.
There was an effort to develop an alternative payment system that was set up involving India and Iran and a number of countries that wanted to get around international sanctions. These payment systems have had a lot of trouble. And the trouble has come from the fact that they're not backed by a central bank that anybody trusts, especially not for big numbers. And this is all tied to a very complicated question, and if we had another 2-3 hours, we could talk it through. But the U.S. is very intent on preserving the U.S. dollar as the reserve currency of the world. And as long as that goes on, there is leverage against any offshore jurisdiction, and there is the potential of sanction of one kind or another. Now, as far as why is Singapore successful, it's been at this business for a long time. I first visited Singapore and talked to its international bankers in 1974. And I asked, why are you successful? And the answer back was, we're Chinese, and those people on the other side of the causeway are Malay. Now, that's not a socially acceptable proposition in today's world. But that was the answer I got from the Chinese who run Singapore in an extraordinarily authoritarian but benevolent way. So you can do very well, and income will be very fairly distributed, and all sorts of good things will happen. But for God's sakes, don't be an opposition politician in which case you will be consigned to some place nobody will ever find you in again.
I think also, that while we talk about today as a global economy, and the ease of transport of currency, well, not meaning currency, but meaning financial assets across borders and such, it wasn't always that way. There was a time when the financial systems, not the Fedwire and such, but the private banking services were more regionalized. I think with Switzerland taking most of the European market, and maybe the Caribbean taking the South Central American markets, and Singapore primarily catered to the Asian wealth, and that's why they were successful. But now, with the ease of conducting financial transactions cross-border, I think Singapore is starting to see an influx. I mean, I don't have any empirical evidence for this, but certainly from my own discussions.
Yeah, you're correct.
They're starting to see an influx of money coming from other places, especially monies that used to be in Switzerland. In some cases, it's not really, as Tim mentioned early in this discussion in another context, it's not so much the money as the booking of the assets maybe going into Switzerland, but the money may actually still be residing in Switzerland. Or Singapore, I meant to say, money still residing in Switzerland. I think that Switzerland, whether they can continue to be this panacea that I guess you were paid to say, I don't know. We'll see what happens. With the money comes all of the liabilities that come with the money. And I think that you will start to see law enforcement and tax authorities start to refocus on Switzerland once they get done. I mean, I keep saying Switzerland, on Singapore once they get done with Switzerland, and all they need is one big case to pop, and everything you said is by the boards.
Well, I think what you've said points to something that has happened, which is that banks in jurisdictions that are under the gun, like Switzerland, have outsourced a lot of their activity to Singapore.
Because
of course, Singapore is booming.
Yeah.
Right. So now we can say, hey, we don't do this in Switzerland, but here's Charlie, our representatives from our Singapore bank, and he'll be happy to help you. Well, there's going to be a limited run on that one, because it will be a matter of short order before somebody pops out a bunch of bank information and puts it in the hands of a revenue authority somewhere or other, at which point that will blow up and Singapore will have Swiss troubles. But I think the Swiss have done an awful lot of this. We're moving to Singapore stuff, and that's helped Singapore as an offshore center. But the other thing I'll say is probably the most explosive potential future development is the issue of corruption in China. You have probably all seen headlines about various high-level Chinese and how well their families have done, and all of the prosperity. All of that money, or much of that money, is held through various offshore structures. And I think the two sets of offshore structures have been corporations formed in BVI, thank you. Also, Jersey did a big job of pitching its structures to Chinese, but the actual bank accounts and the investment accounts are held in Singapore by entities that were formed in BVI or Jersey. And I think at some point that is going to blow up, because the corruption in China is not sustainable. The amounts of money are astonishing. And even the top of the Chinese Communist Party has figured out they've got to do something about it. So when that happens, you're going to see big change. And in China, when they do something about it, it's not something like an IRS John Doe summons. It's a couple of guys show up at your door, and 4 days later, the thief is shot, and they're out looking for the assets. This is a country where they're very direct and very blunt about the outcomes.
I think if I could just, and I know we're running up against time, talking about mistakes, and sometimes unintended mistakes and sometimes deliberate. When I lived in Hong Kong and was there for the handover, Singapore, and I visited it quite frequently in the 90s, was really, really dozy. I mean, you would go down there on a business trip and the lawyer would say, well, why don't we go and have lunch and play golf? That's changed, and a lot of change took place in terms of private client and private client-related business. It had nothing to do with the Swiss. It had nothing to do with Panama. It had to do with Hong Kong reverting to China. And there was real concern in Hong Kong at the time that Hong Kong would change and it would no longer be the attractive portal for going into the PRC and coming out. Now, many of those concerns, at least to date, have been ill-founded, but a significant amount of private client business which was in Hong Kong moved, and a significant amount of business that would have come to Hong Kong decided that it would go to Singapore. So that was certainly the sort of push that Singapore needed to say, we're going to get into the offshore business in a big way, and they've done so. And more recently, Swiss banks, French banks, funnily enough, gosh, the French banks suddenly decided to boost up their Singapore operations. But I find it fascinating that Singapore is rated so highly as a very free and open place. Those of us who are old can remember when you could only buy the Wall Street Journal in Singapore on a restricted basis. You had to be permitted to buy it and read it. They regularly sued newspapers that wrote articles they didn't like about the government. We all know about chewing gum. We all know about whipping American teenagers who did a key job on cars. And certainly when I was visiting Singapore, I heard from my private banking people that if you imported children's videos from London, you had to go down to the post office to collect them, and they would actually look at the videos to make sure that they were appropriate. So don't be fooled that Singapore is a free place. It may appear to be a free place, but it is far from it. And that may be part of its success, I agree, but I don't think it deserves the rating that it gets for being free and open. And the rule of law is managed in Singapore, be under no illusions, it is managed. In terms of how it will do, I think Dan and Jack have highlighted some problems that it may face. The enthusiasm there is very great. Can it overcome some of the threats? I think it probably will. It has a very dedicated, hard-working, intelligent workforce. It has huge advantages. And it also happens to be sitting right in the middle of the world that will see probably most of the growth in the foreseeable future.
All right, as we're coming up against the time, let's just go down the row. Final words on the future of offshore and competition. Dan?
Well, I would say that the issue with offshore remains secrecy, absolute, total, unequivocal financial secrecy. I know there are many in the room who believe that there's nothing wrong with that, but the fact of the matter is that financial secrecy, the absolute, total, complete secrecy afforded to private clients is only something that I believe is needed by those who need the secrecy, and that's generally criminals, money launderers, tax evaders, and others. There has to be some discussion at some point about when we stop talking about secrecy and we start talking about privacy. They are different. They are not the same. Even though some try to blend them and say they are the same, everyone has a right to financial privacy. No one should have a right to absolute, total, unequivocal secrecy that protects them not just in terms of assets from others in a private sense, but also protects them from any kind of viewing of their lifestyle or whatever by law enforcement and legitimate government agencies. So I think that discussion, we need to move away from just talking about the services that are provided at some point, and at some point get to the root cause of why this is all profitable in the first place.
Jack?
My thought is that this is the 12th annual Offshore Alert Conference. I think there'll be enough stuff going on in the offshore world so that David Marchant can run these conferences until he's ready to retire at age 70. And the issue of what will be the content will be the whole problem of resolving how to make various systems that the governments agree to, if they ever get to agree to them, actually work. Implementation of any of the ideas that are floating around now are going to take years. And I don't think anybody need worry about having a job.
I would say probably that there's going to be increasing tension between traditional offshore centres and sort of so-called double tax treaty or sort of mid-shore jurisdictions. Being in Singapore last week, there's certainly a lot of excitement there about Singapore itself becoming a jurisdiction to compete with and BVI and Cayman, rather than BVI and Cayman work being done out of Singapore. So I think it has been a bit of tension for a bit of time between Mauritius and BVI and so forth. I think that tension's only going to increase. But I think overall, offshore centres will be around for, as Jack was saying, around for a very long time, and I think it's a good thing.
Tim?
Well, I keep trying to retire, but haven't succeeded yet, so I'll have to take Jack's views on board. Yeah, I think the major offshore financial centres will be around. They all face both domestic and international challenges that hopefully they will overcome. They do need to be flexible. I mean, that's been the way of the world. And as one tax advantage or regulatory advantage disappears, then other ones are created, usually by our colleagues in New York, London, Hong Kong, Tokyo, etc. And I think the appropriate commitment by governments in these OFCs and the need to earn a living will ensure their survival, but it's not going to be easy. And I think the long term that Dan has mentioned, the long-term game plan, I think people who are in the business in OFCs and our governments should understand that the people who sit, not so much in Washington, although they are also long-term people, but if you look at the people who sit in Brussels particularly, and the people who sit in these international organizations, they tend to have very long-term agendas, and they're there for a very long time. So don't for 1 minute sell them short. They don't mind if something takes 10, 15, 20 years, and some of the things that are happening today will perhaps not bear fruit for them for many, many years, but they are determined to put in place a structure that will improve the revenue performance of their respective parents, i.e. the countries they come from. And the biggest potential long-term threat that I see for offshore financial centers in terms of cost burdens being imposed by all of these international initiatives, which simply may result in people saying it's just so expensive to do these structures and to do them legally in a way that produces the advantages we want, that we're not going to bother. And I think that is definitely a threat. And the idea of, as I was talking to Dan before we joined the panel, the development of the identification number. Now, you may think it's benign. You know, under FATCA, we have the GIN, but there is a international movement developed by the Financial Stability Board, which is in Basel. There's a subset of, it's a subset of the, you know, the G. How many Gs have we got? The Russians have just been kicked out. But it is endorsed by their political masters. It is relatively unaccountable. But it is busily, as some of you may know, developing a procedure whereby every entity, whether domestic or offshore, that effectively engages in the securities markets around the world will have a legal entity identification number. It's called an LEIN, and the macro policy is now starting to be played out, and both onshore and offshore jurisdictions are asked whether they will voluntarily join this program, which means that any entity formed in an onshore or offshore jurisdiction that deals on the New York Stock Exchange or the London Stock Exchange or deals on any of these global markets, in order to be able to participate in those markets, will not only have to give a name, but will also have to give a number. And once you get a number, it becomes much easier to track the transactions and track the history of these entities. And if you combine that with the move to beneficial ownership disclosure, you do end up with a very interesting number of pieces in the jigsaw. I will leave you all to join the dots.
I think the future of offshore financial centers is quite bright, as long as what Jack talked about, the destabilization that comes about from corruption in countries continues, as long as there's flight capital, and it seems that it's getting worse instead of better, that offshore financial jurisdictions will be recipients of that flight capital. I want to thank our panelists. Thank you. It's awesome. tea and coffee now, I think. Is that right? Oh, questions, more work.
Tell me what.
The question I have is, isn't this pursuit of income tax at the cost of eliminating what we see as eliminating personal liberties, substantially undermining the free market economies? And isn't that a disastrous cause for the abominable economics that we see in every OECD country? And would you agree that the failure of these policies, which they're pursuing all the harder now, and the policies of the OECD are failures and should be... Do you guys believe, would you agree that the OECD in pursuing a effectively governmental new world order, which eliminates personal liabilities in favor of collective action, is better for individuals and the economies of the countries they live in versus the enjoying the benefits of the free market economy? You mentioned, of course, we have economies that are run by populist Marxists and economists at all the OECD countries. So, what would you say that the OECD policies and the policies?
Go ahead, let them answer. Go ahead, Jack.
I'll take a shot at answering that. I'm not a particular fan of the OECD, which is in large measure politically unaccountable and very non-transparent, and really a forum for major treasury departments and central banks to play out what they like to play out. But never fear, I would hardly worry that the OECD is going to put a crimp in what you describe as a free market. We haven't had really free markets for maybe forever if you talk about an economic definition of a free market. What we have is oligopolistic markets, and the problem is not too much taxation. The problem is the failure to use tax money to solve various very pressing social and infrastructure problems. Here in the United States, the most obvious one is how many thousands of crumbling bridges and highways that there's no money to fix. So the notion that somehow taxation is ruining the world is kind of crazy to me. It's an essential. And you wouldn't be able to have
I didn't say that
national
taxation. I'm
defense or
specifically
anything else
focusing.
without it.
Jack, that doesn't answer it. I mean, I'm specifically focusing on income tax.
Right.
Now, the fact is that what you talked about is I've been practicing a long time. There is no definition in the United States income tax code of income. It takes 75,000 pages to describe income deductions, credits, and exclusions. And there is no OECD country that has a definition of income. And the OECD itself has no definition of income. And the very idea that you can put together a system that is going to be based on taxing income is fundamentally absurd. And that is the result we get.
We don't have, I think, the week we would need to finish out that debate. So I'm going to just call it ended here, and I'm happy to talk to you after the panel's over.
Okay, additional questions?
I have one follow-up. I noticed that several weeks ago, China and Germany, the Bundesbank agreed to a yuan facility to facilitate exchange of trade between Germany and China. The same is true between the Bank of England, between the UK and China. Would you agree that the rise of these alternate use of currencies and the rise of the cyber currencies are going to be the new tax havens?
I think that's a second question that's going to be dealt with fairly well in a session that we have coming up on Bitcoin. The cyber currencies more or less address the friction of a transaction as opposed to the substance of a transaction. There's a gentleman here with a question. Martin?
Martin Kenny from the BVI. Both Jack and Dan put on a good argument or a robust argument about a dynamic tension between corporate taxes and good social order and peace with the folks. That if the chief executive officers are getting bonus too much, that people will become upset and there'll be civil unrest, I think was the implication of the argument. Although I just looked up on the Google that according to the Brookings Institute Tax Policy Center in 2012, in this country, only 10% of all revenue that were poured into the U.S. Treasury came from corporate income taxes. So I think there may be perhaps the fact that it's only 10% may support your argument, but it may weaken it.
Well, I think that the real issue is it should be a higher percentage, and it's been declining because of this system. And I think the reason you have the discussion you have in the OECD is precisely because it's declining, and precisely because so much income is being shifted around because it's all based on patents and intangibles, and it's easy to shift. Now, I think there will be changes, and that revenue picture has to change if any of our social problems are to be solved.
Also, just a quick point to Tim. I'm not so enthusiastic about suing nominee offshore directors as being a way of proving some level of responsibility on their behalf because of the problem of circular indemnification rules, where in Cayman and BVI we have issues dealing with whether or not a director who's a nominal director can seek indemnity when he's sued by the corporation he serves. It's a very complicated issue that would take 2 hours to debate, but it's a huge hurdle. Also, our commercial court in the last year ruled in a case called Spectacular and Citco that there may be, at least in that case, the court found a lower standard of care for nominee directors versus so-called substantive directors.
I'm sorry to hear that about the BVI. I agree with you. Indemnification exculpation is a huge issue, and it's caused significant log jams of processing liquidations in the jurisdictions. And the only way to deal with that, and I assume it will get to the agenda at some point in the relevant jurisdictions, is legislation. And I mean, that discussion goes on the whole time, how far you should limit contractual indemnifications, not only for directors but for trustees in trust deeds. And that's an issue that I agree needs to be discussed. And we are all aware of the cases where this has been highlighted, where effectively immediately the liquidator sues the directors counterclaim under their service agreements or articles of association, and so billions of assets are frozen while the courts decide how that's going to be unwound. So yes, it is an issue, and it is an issue that the only way to deal with it is through legislation, because the judges can only apply the law as it is. I agree with you.
I just want to comment on the earlier question, which is just to say that, you know, so much, particularly in terms of tax policy, is a matter of perception. It's not just a matter of statistics and numbers and percentages. It's perception. And in the United States, at least, there is a perception that all who benefit from the economy that we have, the services that we provide, the freedoms, the opportunities, the cost of that is something that should be shared in a proportional, measured way by all. And there is a general perception, rightly or wrongly, within the United States that corporations, major international corporations, do not pay their fair share towards enhancing that and promoting it and making sure it continues, and also that the so-called one percenters don't pay their fair share either. So there has to be some balancing between the statistically driven measures of who pays what and the political realities that come from individual human perspective in terms of what's right, just, and fair. And that balancing act is the tough part. It also goes to what the other gentleman said. It's the balancing of all that, getting it to where the least number of people are offended by the tax policy that's in play.
I think when you talk about offense is that some people choose to be offended at anything.
Well, some people will be offended no matter what you do.
You take a look at the United States, you've got 86 million taxpayers and 144 million people either receiving benefits or public employees. There's got to be an intelligent addressing of the percent of GDP that is consumed by the tax revenue as opposed to being applied to things that really are needed. And I agree with Jack. There's a whole host of revenue that's received, and it's not applied properly.
Mm-hmm. But that's the separate discussion that needs to occur. It needs to occur. It should be debated. In a free society, it does get debated. None of us particularly like all of the consequences of it. Since, you know, I will tell you very candidly that since becoming a non-public employee, you know, I now have income that comes from private employment, and I have to pay a tax called the self-employment tax.
Yep.
15.3% of every dollar I make goes to the self-employment tax for the benefit of Social Security. But as a former federal employee, I'm specifically denied the ability to ever collect Social Security. So I find that like I'm being taxed for something that I can never actually participate in, and that seems unfair to me. That's my argument. All right? But then there are others on the other side. So I mean, you're always going to have that. That's the nature of humanity, and that's just fine. That's what keeps life interesting. But the notion that there are simplistic solutions to any of these questions is wrong. They are very complex. They are very difficult, and they require broad thinkers, not narrow-minded, focused people.
Additional questions? Hands jumping up and down, small flares. The concert lighter. Here we go, over here.
Thank you.
And this will be the last question before break. Sorry. Go ahead.
Roger Parent. How's that working out for you, Dan, that Social Security? You know, I'm probably one of the...
Oh, you didn't want an answer?
I think I know the answer. I'm probably one of the few people in this room that actually makes their living doing taxes. And so I'd like to sort of address Jack and Dan. Until we have a system where everyone that makes a certain level of money has what they consider the same tax as the next guy making that same amount of money, I think you're going to have the problems that you have. One of the issues that I have is I am fiduciarily responsible to my clients to get them to pay the lowest amount of tax. And while we have to do that on a legal basis, no question about that, no argument about that, the pressure is always on to find the next best thing. And when the perception is that if the three of us make the same money, one of us might not be paying the same amount of tax, and therefore we need to find somebody, I think that really creates a problem. And the issues that both of you are dealing with is a system that's so convoluted and screwed up that it just needs to be thrown out and started over again. Now, I've been doing this for 30 years, so I keep dealing with the next change and the next change and the next change. But that creates the problems that both of you are dealing with. And again, I'm not talking about illegal moving money offshore and throwing it in a paper bag. But until that gets solved, neither one of your issues are going to be dealt with.
I couldn't agree with you more. And the problem underneath that is currently the political system and political fundraising as it exists. Right now, the committee that newly elected members of Congress most want to be on, and that's both House and Senate in the United States, is a tax writing committee. Why? Because they know they can get the most political contributions from people who have an interest in getting a wrinkle in the tax code. And the people who are on those committees can then distribute money to other people in the Congress to get legislation they want passed. Now, that has resulted in a tax code that is unfathomably complicated, so complicated that even tax lawyers have trouble properly sorting it out. Years ago, you could do it by putting fingers in different sections of the regs. Now you don't have enough fingers, you don't have enough stickies, you're trying to make different regs make sense, and none of them make sense. And even the people who are writing the regs can't make sense of the law that was just passed. We have to deal with that issue of the money in politics and the money particularly going into the system that writes the code. But this is a huge problem. Again, we could have a long discussion about it, but it must be resolved because the consequence has now reached the level of absurd, as you rightly say.
But yeah, the closing note to that is Charlie Rangel of U.S. House got in trouble for his taxes, even though he's a member of the committee that passes the laws on taxes.
Sure. I just want to say I agree with you 100%. Total agreement with you. The last time there was a major rewrite of the code that I recall was in the Reagan administration when it was reduced, and since that time it has grown exponentially. I was in the tax business. I was in the tax business for 35 years before I retired. And I remember when I got hired by the IRS in 1977, they gave me a copy of the Internal Revenue Code and a copy of the Treasury regulations, and they were like a single bound volume about that thick. And when I left the IRS, it was like multiple volumes about this thick. Okay, so I agree with you, but, and I hate to sound like a pass the buck person here, but where's the problem in that? What is the origin of that issue? It is what Jack referred to a moment ago, which is all the tax writing people that keep implementing personal, the new latest deduction to cater to a particular contributor, and then how that gets used by others to reduce taxation. That's why this will never go away. It will be here forever.
Okay, thank you very much. Please let's enjoy the coffee and refreshments. Again, thank you.